Good afternoon, everyone. My name is Jeremy Herman. I'm a lawyer at Samfiru Tumarkin, LLP. It's great to be with you again. I've hosted a bunch of these Q&A sessions, and it's always great to be back to get your questions, to educate you, and to answer your questions live. As you know, we host many of these Q&A sessions every week with our lawyers hosting across Ontario and in Alberta and in British Columbia as well, so that we can try to get questions from all across Canada and different jurisdictions, and to ensure that you get the workplace issues that you have rectified and get the answers that you need to do that. As I usually do, I'm going to start off with a very important topic before we dive into questions. And what that has to do with is what we call a limitation period. So the law has constructed a limitation period of 2 years, generally speaking, to commence a lawsuit or a legal action or formal proceedings against your employer. And this is very important to know, because it's critical that all of the listeners out there, if you have workplace issues, don't sit on them. You have to, even though it might be a daunting process, you have to act on them immediately, because you could potentially run into a situation where you finally decide to do something about an issue you're facing at the workplace, and it's too late. And in fact, I just dealt with very recently, earlier this week, I dealt with a person who contacted me, and it was almost 3 years ago that she had a pay cut. And it was a pretty significant pay cut, and she didn't do much about it. And she waited almost 3 years. And on the face of it, that would be likely a termination, a pay cut like that. It would be what we call a constructive termination, which I'm sure I'll speak more about later in this session. But she couldn't do anything, because she was simply time barred from bringing an action or a lawsuit against her employer. So I want to urge all of you out there, like I said, if you have workplace issues, if you're unsure even if something is an issue, but it might be, and you want to get answers to that, you can ask your questions now. I'll answer them live. But you should also follow up with us. Contact us at help@employmentlawyer.ca, and we will try to answer your inquiry as quickly as possible, as we usually do, and we'll hopefully get to the bottom of the issue for you. So don't sit on it. Ask your questions now and contact us. So putting limitation periods aside, I'll now get into some questions. So we have Sarah asking, what options do you have if your company is being sold, and if you're unsure if you will be rehired by the new owner? Good question. So there are two types of sales that could happen. I won't get into immense detail about it, but could be something called an asset sale or a share sale. So a sale of the assets of a company, or the sale of shares of a company. Now, depending on the situation, there might be, depending on the situation, there would be severance entitlements certainly triggered. And so if your company is selling their business to another company, and you're not sure if you're going to be hired by that new company, then that would be a termination of your employment. And it would be the owner of the company you work for currently that would be liable for your termination entitlements. And you could be entitled to up to 2 years of pay. And the way we calculate severance, as I've talked about, is by assessing your age, your position, how much money you earn, the length of service that you worked for the company, and the general availability of similar jobs in the market. And so in assessing those factors, the company you work for, if you're not rehired, would be liable to pay you severance pay. And again, it could be as much as 2 years of pay, depending on those factors. Now, if you are becoming an employee, if you're transferring your employment to the new employer, then that new employer, if they take you on, there should be continuous service. So you shouldn't be in a situation where you have to sign a brand new employment agreement. And that employment agreement, if it says something along the lines of you're starting from scratch, working for this new company, the buyer of the business, that would be a huge problem. And so if you're in this situation, definitely contact us, because if you're receiving a new employment agreement, there could be a lot of issues with that. And we don't want you to be in a situation where you sign that employment agreement and then you limit your rights if you are ever terminated. So, Sarah, I hope that answers your questions. Essentially, if there's a termination, you're entitled to severance, and the question will be who is liable to pay that severance pay, either the current company or the new company. There's no obligation in every case to bring you on at the new employer, but certainly if you're not brought on, that's a termination of your employment. Okay, so Walter asks, when does overtime kick in for truck drivers driving locally in the GTA? So that depends on very specific circumstances, Walter. Essentially, it depends on the legislation that is the jurisdiction that you work for. So if you say the GTA, but you could be working for a company that's a federally regulated employer as opposed to a provincially regulated employer. And so the circumstances could be very different. So what I urge you to do, Walter, is to contact us at helpanemploymentlawyer.ca, and we will go over your situation in more detail and advise you on if you're entitled to overtime pay, because it's an important topic, and I want to make sure that the answers you get are accurate. So I'll need a lot more information for that one. Okay, so moving on, we have Raina asking, who can you complain to if you're experiencing bullying at your job, but the perpetrator is a manager? We don't really have an HR department. A great question. And it's a difficult situation when you don't have an HR department and you feel like you have a lack of recourse because you don't have people to turn to about these issues. And even more so, if the bully is a manager, that makes it even more difficult. I understand. So, Raina, in Ontario, there is legislation that says that your employer has a duty to protect the health and safety of workers at the workplace. Okay, it's called the Occupational Health and Safety Act. And if there's bullying going on at the workplace, then that would be a breach of the Occupational Health and Safety Act if your employer receives a complaint and doesn't properly investigate or figure out what's going on here. They have that duty to investigate and to rectify the situation. So you'd have to file a complaint, and I know it's a difficult decision to know who to file a complaint to. I wouldn't file it to the manager because they're the bully in this situation, but someone with decision-making power, it could be the owner of the business, it could be some other manager, maybe a director, someone who can do something about this, and not only who can do something about it, but someone who has a duty to do something about it. And like I said, that duty arises from our legislation, the Occupational Health and Safety Act, and it's a very common issue. In fact, this morning, I spoke with somebody who was dealing with bullying at the workplace. And in that situation, there was an HR department, but the HR department was not dealing with the situation properly. So that would also be problematic because there was a formal complaint made, and there was a body in the organization, the HR department, to deal with that complaint. But it wasn't dealt, the investigation wasn't carried out. They kept delaying it. And that, again, would be a breach of the Occupational Health and Safety Act. You could bring formal legal proceedings for that, or you can also claim that it is a constructive dismissal of your employment, which means that you have been constructively terminated. It means you've been terminated not outright by your employer, but there's a change to the fundamental duties of your employment. And one fundamental term of your employment would be that you work in a safe environment. And so if it's an unsafe environment, you can claim that that's a constructive dismissal. So, Raina, I hope that that answers your question. If you have a follow-up, feel free to put it in the chat. Okay. So I have another question on YouTube from ClickSub. I was fired last week for calling my boss incompetent. She goaded me into it. I've worked there for 10 years. Okay. Good situation. That's a meaty situation. So if you're fired for calling your boss incompetent, that is problematic, and your boss might have fired you for cause. I'm not sure if you were fired without cause or for cause. Without cause would mean you were fired and your employer is taking the position that we need to terminate you for what you did, but we're going to pay you your severance pay anyway. We're not saying that we have to withhold your severance pay because of what happened. Or it's very likely in this case, based on my read of it, that you were terminated for cause, which means your employer said what you did was so bad that we are withholding your severance pay, which you're normally entitled to as a result of what you did. And that's a very high standard for your employer to meet. Your employer has the burden of proof to show that your normal entitlement to severance pay must be withheld because of what you did. So it's not you who has to prove that you're owed severance pay. It's your employer who has to prove that given what you did, you are not owed severance pay. And for simply calling your boss incompetent, I need to know more details, but typically speaking, you would probably still be entitled to your severance pay. There's a very good chance of that. And so if your employer terminated you for cause, that's simply a legal position. It does not mean that you're actually not entitled to your pay. So definitely contact us at help@employmentlawyer.ca. And also, as you see on the screen, we have this very cool tool called the Pocket Employment Lawyer. And what that does essentially is it allows you to put in information regarding your circumstances, your age, how long you've worked at a company, what your job is, how much you're earning, what jurisdiction you're in, and asks you all these basic questions. And essentially what it does is it tells you what your entitlements would be if you're terminated. And it is a bit of it generally tells you your entitlements. Obviously, there could be circumstances that change that. Either you could be entitled to more than what our tool says or possibly less. But the point is that it's a very good tool to get a sense of what you're owed. It's a free tool. And as you saw on the screen, you can find that tool at pocketemploymentlawyer.ca. So feel free to use that free tool, figure out what you might be owed, and then contact us to learn more about the situation. Okay, so I hope ClickSub that answers your questions regarding, whether you're entitled to severance pay based on what you called your boss. If you have a follow-up, feel free to ask. Okay, getting to more questions here. So Leanne on Facebook asks, my daughter works as a bartender at Send Games. The employer, I guess, is a good service company, and they cancel people's shifts after they book them. Is there an obligation to pay her or the others anything, and is there a timeline? Thanks. Senator Games, sorry. Okay. So Leanne, this is getting into a bunch of things. So first of all, I'm going to jump to your last point, timeline. I spoke about this at the beginning of this Q&A session. There is a timeline to commence formal proceedings against your employer. So if your daughter would potentially sue her employer, she has 2 years to do it from the time that this incident occurred. The incident in this case would be changing the shifts. From that time, she has 2 years to deal with it in a formal legal way. So I hope that answers your question about a timeline. Now, the question about whether shifts can be changed is very circumstantial. It depends on essentially if there's an employment agreement that says that the shifts can be changed at the whim of the employer. Perhaps there is an employment agreement that says that. It's not uncommon in this situation. Perhaps there is no employment agreement at all, or there is an employment agreement and it doesn't say anything about your employer's ability to change the shifts. But that would have a huge impact on this. If the agreement says that your employer can do that and your daughter has agreed to that employment agreement, then that would be legal, and your daughter would not have much recourse in that case. If, however, there is no such employment agreement that says that, and there's no history of her employer doing this, of changing her shifts without her consent, then she can say that that is a constructive dismissal of her employment. And I said I would talk more about that later in the session. So in this case, changing someone's shifts without their consent, if the shift has already been scheduled and it's affirmed, then that would be a termination of your daughter's employment in that case, because the time that you work is a fundamental term of your employment, and your employer cannot just change that without your daughter consenting to it. Again, it will depend on the circumstances, but assuming that there's no employment agreement, assuming that your employer is starting to do this now and your daughter's raising it as a concern for the first time, then there certainly could be severance pay owed in this case. And so your daughter should contact us at help@employmentlawyer.ca. And as you see on the screen, we have tons of resources on these topics online. So feel free to go to our website at employmentlawyer.ca to learn more about what I'm talking about. And again, if you want to actually contact us about it, and I urge your daughter to do so, Leanne, she can contact us at help@employmentlawyer.ca. Okay, let's try to get to more questions here. So Helen on YouTube says, can I revoke a signed extensive settlement agreement within 7 days? I'm a woman over 50 years old. I signed the agreement during the mediation date under pressure. I want to resume human rights. So I take what you mean from that last piece. You signed away your ability to commence any human rights proceeding. So a proceeding in the Human Rights Tribunal for a situation that occurred with your employer, and you want your ability to do that. And so, Helen, typically speaking, if you sign a release, it is if you sign a settlement agreement that has what's called a full and final release, that is a binding deal. And unfortunately, there is not much you can do there. I understand you might have been under pressure to sign that settlement agreement, but most of the time that is going to be a binding situation, and you can't do much about it. Now, it will depend on what the full and final release says. If it does speak to the fact that you don't have any recourse for human rights issues, then that would be binding. But potentially, there are some releases that don't speak to that. And it just says that you can't sue your employer for any of the issues that were dealt with at the mediation, but potentially there is still liability on your employer for human rights issues, potentially. To be honest, it's probably unlikely, but it's worth reaching out to us at help@employmentlawyer.ca, because I would absolutely need to see the document you signed to learn more about the situation, to advise you on whether you have any further recourse there. So feel free to contact us, Helen, and we'll see what we can do. And if you have a follow-up question, as always, please post it in the chat. I just see Helen does have a follow-up question, so let me get to that quickly. So Helen says, how to ensure my employer executes the settlement agreement? What sentences had I better to add to the agreement? So typically, it's very important for you to execute the settlement agreement, and the deal will not be finalized until the employee executes the deal. executes that settlement agreement. Your employer, if there's a line for them to sign, then they would need to sign it as well for it to be a full final resolution. Again, Helen, I need to see that agreement to advise you further. So feel free to contact us and we could take a look at that. Okay, so moving on to a question from Carmela. Our department has recently been cut in half, and now I'm doing twice the amount of work I was previously. Do I have any rights to refuse? Yes, you do. So if you're doing some extra tasks, right? If things are really busy with your employer, or they had to terminate people, you're one of the ones who stuck around. You were not terminated, but therefore you have more work to do. If it's some extra work, you don't have much recourse there. But most of the time, if there's a lot of extra work piled on you, you do have a right to refuse, and you can even say that is, again, a constructive dismissal of your employment. Your employer has not terminated you outright. They have not said you're terminated, Carmela. But what they've done is that they've changed fundamental terms of your employment. And that fundamental term here would be the work that you do and how much you work, and potentially the hours of work if you're working many overtime hours as a result of the extra work you're doing. And so in that case, that could be certainly a constructive dismissal of your employment. If you do not consent to it, if you do consent to it, then there's a problem. You may not be able to claim constructive dismissal. So if you have not consented to it, then please contact us. Let us learn even a little bit more. Based on what you're telling me, there very likely is a constructive dismissal here. And again, you'd be entitled to full severance pay, could be up to 2 years, depends on your circumstances. Check out, again, our Pocket Employment Lawyer tool at pocketemploymentlawyer.ca to find out the amount of severance that you're likely owed, and then contact us at help@employmentlawyer.ca so that we can learn more about your situation and get you the severance that you deserve. Okay. Okay, ClickSub says, I'm in the UK. Your answer is helpful. My pleasure. I'm happy that it was helpful. If you're in a different jurisdiction, then certainly the answers depend on the jurisdiction, right? We have different laws based on the country you're in, based on the state or province you're in. So I'm focusing on Ontario right now, but I'm happy that irrespective of that, the advice I provided was helpful. Okay, so we have another question from Julia, and Julia on YouTube says, is it allowed for an employer to fire you under false allegations? Can I claim a wrongful dismissal for this? You absolutely can claim wrongful dismissal in that situation, Julia. If your employer has fired you, typically speaking, and some of you may not know this, your employer is allowed to terminate you. They're allowed to do so as long as it's not for discriminatory reasons. So if your employer is terminating you and you have a reason to believe that it has to do with your age or your sexual orientation or your sex or your race or ethnic origin, that would be very problematic, and that would be illegal, and that would be discriminatory under the Human Rights Code in Ontario. Now, even if that has not happened, even if you were just terminated, not for discriminatory reasons, but you were terminated under false allegations, if you were withheld your severance pay, then you absolutely could be entitled to it, depending on what those allegations are. If they're false, then yes, you're entitled to full severance pay. If you were not terminated for cause, you were terminated without cause, and your employer is saying you're entitled to severance pay, but they're not giving you enough, check out our Pocket Employment Lawyer tool, figure out what you're actually owed, because most of the time your employer is not offering to you what you're actually owed, and contact us, and we will investigate further to make sure that you receive the severance pay that you rightfully deserve. So Julia, I hope that answers your question there. Okay, so I'm going to quickly speak about another important topic here. And I spoke about this during our last Q&A session, and that has to do with severance pay during recessions. So, there's a lot of news right now about whether we're in a recession or whether we're soon approaching a recession in 2023. It's all over the media. I'm sure you've heard about it. And the question is, what are your rights in a recession as an employee? If you're terminated, are you owed severance? Are you owed the same amount of severance? And the answer is absolutely you are. Many might think that we're in difficult times. My employer might be in a difficult financial situation, and therefore maybe I'm not entitled to severance pay. But that is absolutely incorrect. You are entitled to severance pay regardless of being in a recession. You're entitled to the same amount of severance pay. So again, it depends on your age, your length of service, your position, how much you earned, etc. But that will not change because we're in a recession. In fact, you might actually be owed more severance pay because we're in a recession, not less. And the reason for that is because another key element that we assess for what your severance pay will be is the availability of similar work right now. And in a recession, it very well could be that there is not the same jobs available to you in the market. So you're terminated, but you're looking for a new job. It's even harder to find because we're in a recession. If that's the case, then you are likely owed even more severance pay than you normally would be if we're not in a recession. So don't hesitate. Just because we might be in a recession or approaching a recession, you absolutely should contact us. Find out what your proper severance entitlements are. You can contact us again, as you see on the screen, at helpanemploymentlawyer.ca. And so I wanted to urge that point. It's a very important point right now. So diving into more questions. So we have a question on Facebook from Jacob. And Jacob says, my employer made everyone permanent work from home effective November 1st after being a brick and mortar operation for 20 plus years. I've been with them for 2.5 years. And you've been on medical leave for 2 months. Okay. So from what I understand, Jacob, you're saying that you've worked there for a long time, which is excellent. And you have always worked in office, and now they're asking you to work remotely. And it's permanent, and they're forcing that upon you. So this is an interesting situation because usually I'm dealing with situations where it's the opposite. You're working remotely, and your employer is saying you have to come back to work. It looks like here it's the opposite situation, but the answer doesn't change very much. That very likely could be a constructive dismissal of your employment. So again, not an outright termination, but your employer changing fundamental terms of your employment, which is where you work, and saying that you have to now permanently work in a different space. So that could be, and even if your employer, I keep getting comments from you, even if your employer loses their office space, it depends on the situation. So I need more details. I definitely urge you to set up a consultation, Jacob. Contact us at helpanemploymentlawyer.ca, and we'll answer that question more thoroughly. But that could be a constructive dismissal, so don't sit on that issue. Look, so that's it for today. It was great being with you again, and I'm always happy to be here to answer as many questions as I can, and also to raise topics that are particularly important right now in the employment law sphere. So thanks for joining us. I believe we have another Q&A session coming up very soon with my colleague, Samira Belitsky. So please join in for that. And thank you very much. Have a great day, everybody, and take care.